law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome, folks, to the Law of Self-Defense News and Q&A show for September 9th, 2021. For those who may not know, I am attorney Andrew Branca for Law of Self-Defense. Thank you very much. That's greatly appreciated. As the title of this show suggests, we cover self-defense law, use of force law, meaning defense of self, defense of others, defense of property. That's all we do at Law of Self-Defense as a legal practice. And this weekly show is our news and Q&A show, where we discuss use of force events in the news. And we'll also take your questions. Some questions have been sent in ahead of time. If you'd like to send in a question for our consideration for a future show, you can always email those to us at show@lawofselfdefense.com. Or if you're watching this live on Facebook or in our membership area, you might consider just asking your questions live in the comments, and time permitting before the end of the show. We try to keep this to an hour. I'll answer the questions as time is available. So before we jump into the substance of today's show, I do, of course, want to mention our sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. Effectively, what CCW Safe promises its members is to cover their legal expenses if they're involved in a use of force event, and those expenses start big and get bigger fast, folks. It's very easy to incur tens or hundreds of thousands of dollars of legal expenses even before you get to trial. Imagine a circumstance in which you're threatened, you make the other party aware that you have a gun and you're prepared to defend yourself. Maybe you don't even present the gun. You certainly don't fire a shot. You don't shoot anyone. No one's hurt. And then you find yourself charged with aggravated assault with a firearm, a felony good for 10 to 20 years in most states. You retain an attorney to defend against that charge, as you ought to, and it's very easy to find yourself paying a retainer of $30,000 to $50,000 pre-trial. If you've shot and killed someone in self-defense and find yourself charged with murder or manslaughter, very easy to burn through $200,000 in legal expenses pre-trial, and then just more for the trial itself. So unless you have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, which is as if the rest of your life depends on it, because it really does. And that's what CCW Safe does for its members. Now, there are alternative companies out there that offer similar services. I've looked at all of them, as you might imagine, and found that CCW Safe by far is the best fit for me. I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser after the show to lawofselfdefense.com/CCW Safe. And if you decide to become a member with them, you can save 10% off your membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. All the more important these days, folks, especially with politically motivated prosecutions, which are all more common than ever, to assume the risk that you could find yourself prosecuted for a threat or use of force, even if it is on the technical legal merits, lawful self-defense. You'll want that financial backing behind you. Okay, so what do we have to talk about today? Well, there's a few stories in the news the last few days. Excuse me a moment. So, what I wanted to talk about was this Larry Elder egg assault. For those who may not know, Gavin Newsom, the governor of California, is being subject to a recall election for good reason. And it seems that one of the leaning candidates for the governorship running against Newsom in this recall election is Larry Elder. Now, Larry Elder is a black man, for those who may not know, but a conservative. I believe he identifies as a Republican, certainly on the right rather than the left side of the political spectrum. And he was recently walking down a California street when I believe it was a woman. It's hard to tell, but a person wearing a gorilla mask, a white person wearing a gorilla mask, the gorilla mask having purple hair, threw an egg at Larry Elder. I believe the egg missed. And Larry Elder moved on with the folks he was walking with. A couple stayed behind to interact with the egg holder, the egg thrower, rather. The gorilla mask egg thrower had friends of hers with her, apparently more white people, and they began to engage in some pushing, shoving, threatening conduct towards some of those people who had accompanied Larry Elder. Not with Elder himself. He had continued walking away as he had been. So it gives us an opportunity, this egg throwing thing, to talk about a few traditional concepts of use of force law, particularly the criminal offenses of assault and battery, all of which arguably may or may not have occurred in this event. So we talk about the egg throwing. Let's pretend, for example, that the egg had in fact struck Larry Elder. What we would have there is a simple battery. A battery is an unlawful, undesired, offensive touching of another person, the throwing of an object. If the object impacts the target, that's considered a touching. So that's the battery. That's the unlawful contact, harmful, offensive contact with the other person. The often accompanying charge to battery is assault. Assault doesn't require that anybody is harmed or touched in any way. Assault is putting someone in fear of imminently being offensively or harmfully touched or contacted. So if you run up to somebody with a raised fist as if you were going to punch them and put them in fear of being struck by the punch, that's an assault, even if you don't contact them. If you do contact them, that's a battery. So if you run up, put them in fear, and punch them, well, then you've committed the assault and the battery. Assault and battery. You can, of course, commit assault without battery, without actually making contact, and you can commit a battery without an assault. In this particular case, for example, it appears that Larry Elder never knew an egg was being thrown at him. If the egg had struck him, he would have been the victim of a battery, the undesired, harmful contact, but not an assault because he was never put in fear of the egg. He didn't know he was facing an imminent threat of being struck by the egg. And in this particular case, the assault or battery in question would be a simple assault or a simple battery, meaning an assault or battery or both that threatens mere non-deadly force. So it doesn't threaten death or serious bodily injury, death or serious bodily injury being the definition of a deadly force aggression. So we'd have a simple assault, simple battery, normally a misdemeanor. Now, it might not be a misdemeanor depending on aggravating circumstances. We'll talk about those in a moment. If the assault and battery does threaten serious bodily injury or death, then it's an aggravated assault or battery, normally a felony, not merely a misdemeanor. That can be aggravated even further typically in terms of sentencing, if a weapon is involved, particularly if a firearm is involved, and then we have gun sentencing enhancements. And an aggravated assault, so putting someone in fear of imminent death or serious bodily injury without ever contacting them. So this is the situation I talked about in the context of CCW Safe, where you alert someone who you perceive as threatening you that you have a gun. Stay back, I have a gun. You may not draw the gun. You may not certainly fire the gun. Don't shoot them. So there is no aggravated battery. You haven't actually contacted them. But you put them in fear of imminent death or serious bodily injury. That was your purpose when you said, stay back, I have a gun, to change their aggressive behavior. You've checked all the boxes for aggravated assault with a firearm, good for 10 to 20 years in most jurisdictions. Now, of course, you can raise as a legal defense the defense of justification, self-defense, or defense of others, depending on the circumstances. But you could be obliged to raise that defense in court, in which case you'll have incurred all the legal expenses we talked about earlier when we talked about CCW Safe, unless you're fortunate enough to live in a self-defense immunity jurisdiction, in which case you can raise that legal defense of justification pre-trial in a not free, but relatively inexpensive pre-trial hearing, a few thousands of dollars instead of a few tens of thousands of dollars. And perhaps if you meet the legal standard for self-defense within the context of that self-defense immunity hearing, the hearing judge may grant you immunity from prosecution and or civil suit, depending on which jurisdiction that you're in. I'm a big fan, as you might imagine, of self-defense immunity laws because it provides this opportunity to have the issue of self-defense adjudicated, meaning a final ruling is achieved without necessarily being compelled to go through the full expense and length of a full-blown trial by doing it instead through this pretrial sentencing hearing. Now, I mentioned that normally an assault or a battery that threatens only non-deadly force is a simple assault or a simple battery, normally a misdemeanor, meaning perhaps a few months in jail at worst, some kind of fine that you might have to pay. But a lot of states have laws that aggravate what would normally be a simple assault or battery into a felony if it meets certain criteria. Some of those criteria could be hate crime criteria, if the assault or battery was motivated by, say, racial animus, which would certainly appear to be the case in the Larry Elder event. You can throw an egg at Larry Elder and have it be a political statement, but when you're throwing an egg at a black man and you're wearing a gorilla mask, it sure looks racially motivated to me, especially if you're a white person doing it. Also, there are states, Florida is one of them, that will aggravate an assault or battery based on the age of the victim. So a victim, and I forget the specific age threshold in Florida, it might be 65 or 70, something along those lines, but commit a simple assault or a simple battery upon someone who's older than that threshold age, and it becomes aggravated to an aggravated assault, aggravated battery, a felony. And by the way, a forcible felony under Florida law, which would justify that person's use of deadly defensive force to prevent a forcible felony. There are obviously a lot of both legal dynamics here and political dynamics as well. For example, this person in the gorilla mask, in theory, you'd think, could have been charged with a racial hate crime. Certainly, those of you who remember the Jussie Mullet case out of Chicago, where he alleged someone had put a noose around his neck in a racial attack, some purportedly Trump supporters, people wearing MAGA hats, turned out, of course, to be a complete lie, as virtually all of these cases turn out to be complete lies. But certainly had it been real and the suspects had been arrested, I would have anticipated they would have been charged with a hate crime variation of that assault and battery upon Jussie Smollett, had there been any truth to any of that. That seems unlikely to happen here, because who would make the decision to prosecute at all, much less prosecute in an aggravated fashion? It would be people of the tribe, of the team of Gavin Newsom, and on the opposite team from Larry Elder. So we see the analysis that can be done of this kind of attack based on the legal merits, which is, of course, my area of expertise. But it's also worth considering the political dynamics, the choices that are made in bringing charges, in prosecuting. We'll talk about more of these political dynamics in some other news stories I wanted to share with all of you. I would note that the political dynamics are different than the legal merit analysis. So first you have to do the legal merit analysis. That's really the only way to know if decisions are being made for political purposes. If the decision would be warranted based on the legal merits, well, then it's consistent with the legal merits and doesn't require a political motivation. But when the political charging decision or prosecuting decision is made in a manner inconsistent with a reasonable analysis on the legal merits, well, then it sure looks like it's politically motivated prosecution rather than a prosecution based on the legal merits. Which brings us to another arguably politically motivated prosecution, and that is the prosecution of the three gentlemen in the Ahmaud Arbery case. These were the gentlemen that pursued Ahmaud Arbery in their truck while armed after having apparently perceived him commit an apparent burglary of a home across the street, burglary being a felony under Georgia law. Georgia at the time, since repealed, but at the time had a very broadly defined citizens arrest law that almost certainly justified these men in pursuing, frankly, in arresting Ahmaud Arbery. They never actually made an arrest. They were pursuing Arbery. They asked to speak with him. He charged them, one of the men armed with a shotgun. There was a fight over the shotgun, and Arbery was killed over the struggle over that weapon. And several prosecutors had looked at the case, and the initial prosecutors, there was at least three. One, they concluded that this apparent use of force by these men was legally justified under the circumstances. And there is a rational, legally meritorious argument to be made that the shooting death of Ahmaud Arbery, well, the death of, invariably, it's not a good thing. No one's happy Ahmaud Arbery died, but it arguably was legally justified on the facts and law of this case. But one of the men involved in the pursuit of Ahmaud Arbery had worked previously as a law enforcement officer and for prosecutors in the area, in the prosecutor's office. And so a series of prosecutors initially were, of course, called onto the case, as would be the normal course of events, realized who the participants were, realized they had a personal relationship, recused themselves, and handed the case over to a successor prosecutors. This happened once, this happened twice. With the third local prosecutor, I believe, either he also tried to recuse himself or the case was simply taken away from him and taken over by the state attorney general, whatever they call him, the highest level state attorney in Georgia. And so it became a state level prosecution at that point. It was taken out of the hands of the county prosecutors. But one of those prosecutors now has found herself indicted on criminal charges. So the state level prosecutor has decided to charge her criminally, put those charges in front of a grand jury, just receives an indictment. And this prosecutor, Johnson, has just had to, within the last day or two, had to report to the sheriff's department for booking. And she's been formally charged. She was released on her own recognizance, but now she's facing criminal charges. And the allegation appears to be that she committed some kind of criminal level misconduct associated with this case, some kind of obstruction of justice type of offense. Although the news articles never specify with any precision what this obstruction offense is. Certainly, I don't see any actual obstruction of justice. She didn't decline to have this case prosecuted. She simply said, I have a conflict. I'm handing it to a different prosecutor, which is what she's supposed to do. So nothing prevented the case from being moved forward for prosecution based on her own conduct. Also, it's normally the case that absent really egregious conduct, that a prosecutor's decisions as a prosecutor in the normal course of events for their office, that they're granted absolute immunity for those decisions, that they're not subject to prosecution or civil suit. Now, of course, they might engage in conduct that's truly egregious. If they were to hide evidence favorable to the defense, for example, that would qualify as an obstruction of justice. If they were to bribe people involved in the case, that could readily be characterized as an obstruction of justice kind of offense. So there are levels of conduct that would rise to a criminal level, but nothing that I see in this case. I mean, basically, she looked at the case, she saw who was involved, she knew she or her office had a relationship. The offense appears to be really a political offense, and that she was not hyper aggressive in bringing the prosecution herself. And this appears to me to be simply another part of the kind of scorched earth approach that these politically motivated prosecutions take now. So it's a warning, not just to this particular prosecutor, but to every prosecutor, that, hey, if you see a case in which there are prospective white defendants who've been involved in the death of a black victim, you better be hyper vigilant about prosecuting those defendants, regardless of the underlying legal merits of the case. Or not only will you suffer a political price, and this prosecutor had already suffered a political price, she lost her bid for re-election, so she's no longer a prosecutor. And of course, that's a legal process issue, not a political process issue. If the people in her district don't want her as prosecutor, they're free to elect somebody else, which is what they did. There's nothing wrong with that process. But not only is she to pay a political price, which she paid, but now she's looking to pay a criminal price for having made what appears to me to be a perfectly normal and reasonable prosecutorial decision. Not even declining to prosecute the case, but simply declining to do it herself because she had a plain conflict of interest with one of the participants in the case. Perfectly normal. And especially when you contrast this with decisions by Soros-funded prosecutors elected throughout the country who are seeing obvious acts of violence and property crime and simply announcing, we will not prosecute these cases. So theft under $1,000, we're not going to prosecute it. You want to go to a CVS and steal $999 worth of stuff? You're not going to jail because we're not going to prosecute those cases. Lots of other normally criminal offenses routinely prosecuted. These Soros-funded prosecutors are simply deciding not to bring those cases. Now, is that a violation of their oath of office? I would argue yes. This is not merely a discretionary resource decision. It's not saying, hey, we have 20 prosecutors that are all fully committed to murder cases, so we're going to go light on the shoplifting cases. That's a standard allocation of resource decisions. You have limited resources. You can't go after everybody. You plea bargain what you can. The rest of it may not get prosecuted. But that's not what's happening with these Soros-funded prosecutors. They're announcing as a matter of office policy that they are not going to prosecute cases that are obviously criminal acts simply for political purposes. Those prosecutors are not getting criminally charged. It's fascinating. The prosecutor for the Freddie Gray cases out of Baltimore, where 6 officers were charged with crimes as serious as murder for the in-custody death of Freddie Gray, who by all appearances appears to have killed himself by standing up handcuffed inside a police van as it was moving. The investigation into their conduct found no reason to bring criminal charges against them. And then Marilyn Mosby, the Baltimore state attorney in the area, announced that she'd run secretly her own independent investigation that provided probable cause to bring criminal charges as serious as murder against those 6 officers. And when challenged to show the evidence of this secret investigation, it turned out the person she identified as leading that investigation said, hey, I didn't do any investigation. So it was all a lie. These 6 cops were dragged into trial on murder charges as serious as murder, on a lie. There was no investigation. She made these charges based purely for political purposes, and she faced no repercussions. She's still Baltimore State's attorney there in that district. And certainly there was never any consideration of criminal charges. Now, some of the officers who were persecuted by her attempted to sue her in civil court for damages for dragging them into court on a completely fabricated basis. And their civil suits were dismissed on the grounds that as a prosecutor, her decisions in office carry absolute immunity, both criminal and civil. So she can't be prosecuted for making decisions as a prosecutor. Even though, in my humble opinion, her misconduct in this case was so egregious, it fully warranted criminal charges. Faking an investigation for the purpose of dragging officers into court on murder charges is unforgivable. But of course, the message they're trying to send here is, hey, listen, maybe you don't want to be a prosecutor, period, unless you're willing to take this kind of heat, unless you're willing to risk going to jail for making a perfectly legitimate legal determination that a use of force was lawful, even if it was a white person who used the force and a black person who was the victim of that use of force, because that can't be allowed to happen. Can't not bring that case to trial. Of course, it's political. We have another interesting case here, which is that of the death of Duante Wright. Duante Wright was pulled over, apparently for traffic violation. Warrant check was run. Turned out he had a warrant on a gun charge. He was a minor at the time, I believe 17 years old, may have been a bit younger, but not an adult for sure. And when the officers sought to make the arrest for the outstanding warrant on the gun charge, he forcibly resisted arrest. And one of the officers was she happened to be female. Her name, I believe, was Potter. And she decides, as Wright is fighting arrest and attempting to he's back in his vehicle now, she attempts to deploy her taser, announces many times, I'm going to tase you, I'm going to tase you. Taser, 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 discharges the weapon in her hand, which unfortunately turned out not to be a taser, but to be a Glock pistol. So she fired around into Wright's abdomen, into his body. Then all the cops involved kind of jump back at the sound of the gunshot. Wright closes the door, drives away, but dies a short distance down the road from the gunshot injury. In fact, I believe I have the actual video of that event. So I'll share that with you. This is shot from the body cam perspective of the female officer involved. There's no gore here. In fact, I don't believe you can even hear the gunshot go off. I think the sound of the gunshot wasn't captured by the body cam, or was above the microphone threshold, or was muted out by whoever made this video accessible in the first place. I do put a little bang text on the screen when the shot was apparently fired. But just to give you a sense of the dynamics here, I'll play the video. Unfortunately, this probably means Facebook will block or blind or whatever they do to today's show, but that's the way it goes. So here's that video of the arrest, of the shooting, I should say, the attempted arrest. Okay, so that's all there is there. Can someone in the comments indicate if you were able to hear the audio on that little video clip? I'd appreciate that. Because if you're able to hear the audio, you could hear her verbal commands, her taser, 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 her I'm going to tase you, I'm going to tase you, before she even made the taser announcement, and so forth. So the reason this is back in the news now is because she's just been charged with manslaughter in the first degree. She had been charged with manslaughter in the second degree, and the prosecutor in the case has added the first degree manslaughter charge. These are all forms essentially of reckless killing. I believe the manslaughter in the first degree is good for 15 to 30 years in prison. So if convicted on that charge, that's the kind of sentence she'll be looking at. And frankly, on one level, I have to say up front that I'm not favorably disposed to an experienced law enforcement officer who believes it's appropriate merely to deploy a taser, accidentally deploying their gun. Those are two different tools for two different purposes. I believe at this time she was actually an FTO, so a field training officer, which one would expect to be a relatively experienced law enforcement officer. Of course, time on the job doesn't necessarily translate into higher capability. We all know people who've, they've been in the job 20 years, but they're really doing the same 1 year level job just 20 times in a row, as opposed to having actually gained substantive experience over that period. So that could be the case here. I don't know. But this case provides the opportunity to talk about some of the various forms of intent or criminal culpability or lack of culpability that could be involved in this kind of case. So they've charged her with manslaughter. What they're arguing there is that's a form of reckless killing. So not intentional killing. She didn't intend to take this person's life, but it was reckless. And what we mean by reckless under the law is it's kind of an aggravated form of negligence. So negligence is when you unjustifiably create a risk of harm and the harm results. So you should have known not to create that risk. Perhaps you didn't know you were doing it, but a reasonable person would have known. You created the risk, harm resulted, and normally negligence is not a basis for criminal culpability. It's a basis for civil liability. So you'd be sued, whoever you harmed, you'd be sued for damages in civil court. Recklessness occurs, generally speaking, when you have negligence and you aggravate it. So now, instead of creating merely a risk of harm, you're creating a risk of death or serious bodily injury. So you're creating a risk of deadly force harm, and you knew of that risk and disregarded the risk, or you should have known of the risk. And a classic example here would be drunk driving. So you get drunk, you get in your car, you drive, you run somebody over, a pedestrian in a crosswalk. By getting intoxicated and driving, you knew you were creating a risk of death or serious bodily injury to others, and you disregarded that risk. It's not like you didn't know you were drunk, right? You didn't know that you'd been drinking. You knew you'd been drinking. You knew you were operating a motor vehicle. You know what that risk is. Any reasonable person would. You disregarded the risk and the harm resulted. So it's not merely negligence, it's recklessness, criminal recklessness. That's generally the basis for this kind of involuntary manslaughter type of charge. In this particular case, the prosecutors are arguing that it was the mistaken presentation of the glock when it should only have been a taser that qualifies as reckless. And of course, I'll have to prove that beyond a reasonable doubt at trial. There is a legitimate question to be raised about to what extent Duante Wright created this risk that's the underlying basis of recklessness. After all, if he hadn't forcibly resisted lawful arrest, well, there would have been no need to go to a taser or a gun, right? So he played a role in the creation of this risk. To what extent would that strip away the criminal recklessness of the mistake? Again, I'm not all that sympathetic to an officer who intends to display a taser and ends up displaying a gun. That's not something that should happen. It's also possible, of course, that she could attempt to raise the legal defense of accident. This would parlay with Duante Wright having created the risk that the prosecutor is saying is the underlying foundation for recklessness. An accident is when something bad happens because of your conduct, but there was no way for you to know that your conduct was creating any kind of unnecessary risk, unjustifiable risk. An example might be if someone asks you to move a heavy object from one corner of a room to another corner of a room. Okay, nobody likes to move a heavy object, but it's your favorite aunt. So you say, all right, I'll do it. You pick up the heavy object. You move it to the other corner. You put it on the floor. And unbeknownst to you, the floor joists are rotten. The object falls through the floor, kills someone on the floor below. Now, they were killed because you dropped a heavy object on them. But there was no way for you to know that your conduct was creating a risk. There was no way for you to know the floor joists were rotten and so forth. That's literally an accident. The harm was caused through no fault of yours. An accident is a legal defense, just like self-defense is a legal defense. It's a perfectly legitimate legal defense. I don't have any criminal liability here because it was an accident. There was no way for me to know I was creating the risk. Does Duante Wright's forcible resistance of lawful arrest create that environment for accident? In other words, on a range during training, there's no way that officer would have accidentally pulled the taser, the gun instead of the taser. That only happened because of the circumstances created by Duante Wright, justifying a legal defense of accident in this case. That's, of course, another possibility. Of course, a broader question here is an extra legal question, is a political question, and that is, does anybody believe, and this happened in Minneapolis, by the way, Minnesota. I'm not sure where in Minnesota. But does anyone believe in this day and age, following the Derek Chauvin trial, that any white officer who's in any way involved with the death of a black suspect is going to get a fair and impartial trial in Minneapolis? Does that seem even possible today? I don't know. Certainly, there's nothing about the Derek Chauvin trial or the year of propaganda leading up that would suggest to me that a fair trial is possible, which means not good things for the police staffing in Minnesota or many other urban centers, unfortunately. Then we have another news story. This is not really use of force law related. This is firearms related. And our expertise, folks, here is use of force law. It's not gun law. I'm a gun owner. I've owned guns all my life. I carry a gun for personal protection, have every day of my adult life. So I'm of course familiar with guns, have an interest in guns, but I don't claim any great expertise in gun law. If you have gun law questions, I can always recommend attorneys who do have great expertise in that area. But this news story really caught my eye because of the many levels of stupid in it. So this involves a deputy mayor from a small town in New York State. This town, Airmont, for those not familiar, Airmont is located on the west side of the Hudson River, just above the New Jersey border. If you throw a tennis ball in Airmont, it probably lands in New Jersey. So very close to New York City, very close to New Jersey. New York State is already very anti-Second Amendment, as is New Jersey. And of course, the New York City greater metro area is even more anti-Second A than the state generally. This guy was the deputy mayor. Think of it as assistant mayor. So a small-time local politician. And it turns out he had a bunch of illegal guns. Illegal because in New York State, your guns have to be registered with the state, and a bunch of these were not. Stupid. Folks, I think these kinds of gun registration laws, the gun laws in New York, generally all gun laws applied preemptively to law-abiding, mentally sound American citizens. I believe all these gun laws are unconstitutional. But they're real, and they will send you to jail for a long time if you're convicted on these unconstitutional gun laws. And if you don't like the gun laws of New York, the answer is not to break the gun laws of New York. The answer is to not live in New York. There are many other states you can live in that don't have New York-style gun laws. Move to one of those. If you stay in a state and you break their gun laws and you get caught, you're going to jail for a very long time. So that was the first level of stupid here. The second level of stupid was that this guy had in his possession what they describe as a suppressor. First of all, he had in his possession a suppressor. Now, my recollection of New York gun law, again, I don't claim great expertise here, but that you cannot own a suppressor in New York State, period, unless you're law enforcement. So there is no private ownership, just like there's no private ownership in New York State of fully automatic weapons. Under federal law, you can get licensed to possess such items, and there are many states that don't have a prohibition on the possession of such items. So even Massachusetts, believe it or not, you could own suppressors. You could own, I take back suppressors, I'm not sure about that, but my local range in Massachusetts had a full auto bay. You could own full auto guns in Massachusetts when I lived there 15 years ago. As long as, of course, you met all the various requirements, but it was possible, not in New York. So now this guy is in possession of something in New York State, this suppressor, that you can't legally own in New York under any circumstances, unless you're law enforcement. So it's not like there was a paperwork snafu and he thought it was legal. He knew it was not legal. Even worse, another layer of stupid. He apparently acquired the suppressor over the internet. We all know what that means, right, folks? This is one of those guys who saw the Facebook ad for an oil trap. They show you the oil trap. In theory, I guess the story is supposed to be when you've cleaned your gun and you've oiled it and it's all dirty and has excess liquid in it, you screw on this object over the muzzle and you discharge the gun and it traps the oil coming out of the muzzle. Folks, it's obviously intended to be a suppressor. If you look at the design, it looks exactly like a suppressor. It doesn't look like anything else except for a suppressor. So merely calling it a oil trap is fooling nobody. And it would not surprise me in the least to discover that all these ads advertising these oil trap devices are in fact paid for and run by federal law enforcement. Just in case there's someone stupid enough to actually order one of these things and be in unlawful possession under federal law, as well, of course, if you live in New York State, under New York State law. So this idiot ordered one of these things over the internet. Then they get to his house with a warrant for the gun and the suppressor and all this contraband under New York State law, stuff he's simply not allowed to possess, and they find a locked box. And he tells them, well, I don't have the combination to the locked box. What do you think the law enforcement does when they have a warrant to search and there's a locked box and you won't open it? Well, they open it. They pry it open. If it's a gun safe, they'll just burn it open if they have to. If they have a warrant to get in there, they're allowed to do that. So they get into this locked box, and what's in there but a bunch of forged federal law enforcement identification, FBI identification, badges, various other forms of fraudulent federal law enforcement investigation in this guy's name, as well as, by the way, this guy's passport, this guy's commercial driver's license in his real name. So the idea that he didn't know the combination to this box is obviously ridiculous when his own identification papers are in there. You don't put your passport and CDL in a box you don't have the combo to. So another level of stupid, as if they were not going to get into the box simply because he denied them the combination. So, folks, I caution, this is a cautionary tale. Please don't do any of these things. Please, if you don't like the gun laws where you live, move someplace with more favorable gun laws. Don't have badges if you're not a law enforcement officer, especially badges actually professing to be an agent of a federal law enforcement organization. But I recommend you not even have these concealed carry type badges out there. It looks like nothing else except that you're trying to misrepresent as yourself as a law enforcement officer. If you want a badge, if your heart is set on having a badge, awesome. Go to the police academy, get hired by a police agency, be a cop. They'll give you a badge, and then you're all good. Don't have badges if you're not law enforcement. Okay, another story here. This is one of those feel-good stories that just sends a shiver up and down my spine. And the headline here from the paper, and by the way, all these news stories I'm talking about will be hyperlinked in the text version of today's content, so you can read the full story yourself, including this one. But the headline of the story is a feel-good headline. Texas father shoots man peeping into 10-year-old daughter's bedroom. What's wrong with that? Well, first of all, you can't actually shoot someone simply for peeping through a window. That's criminal conduct, but it's not an imminent threat of harm for someone to peep into your 10-year-old daughter's bedroom. I have a 10-year-old daughter. Such conduct is disgusting, should be prosecuted to the full extent of the law. Nothing good is going to come from somebody who's peeping into a 10-year-old girl's bedroom. No question about that. That doesn't mean you can shoot them. Of course, when you read the story, you discover, well, that's not why this Texas father shot this guy. He apparently he and his wife observed this creep staring into their daughter's window, and they decided to chase this guy, go outside and pursue this guy. And they did so while armed. So they armed themselves with guns. They have guns in their hands, and they chased this guy to a nearby gas station. At this point, I would suggest that this conduct has now become imprudent, not necessarily unlawful, but imprudent. Now, what were they attempting to do? Were they attempting to make a citizen's arrest? Because if they were, I'd be very careful about that. The men in the Ahmaud Arbery case were also trying to make a citizen's arrest, found themselves fighting for their shotgun, having to kill the person they had initially considered arresting, and now they're all being charged with murder. So I would be very cautious about making a citizen's arrest. Were they just attempting to keep eyes on this guy, so when law enforcement responded, they would be able to point the guy out to law enforcement? Well, you don't need a gun in your hand for that. And frankly, the gun in the hand didn't work out well for these people, because they got to the gas station, gun in hand, eyes on this suspect, making themselves aware, their presence aware to this suspect. The father apparently goes into the gas station to call police. And while the father's in the gas station, the suspect manages to take the gun away from the wife. So he takes the gun away from the wife. Now the wife has essentially given a gun to this suspect who was peering in her 10-year-old girl's window. He's armed now with a gun. Then the father comes out of the gas station, sees the suspect with the wife's gun, and shoots and kills the suspect with the gun. Now, can you make an argument of justification for shooting in that circumstance? Sure. If the suspect presented as a illegal, unlawful threat of imminent death or grave bodily harm, and the circumstances seem to fit that, the use of deadly defensive force may be warranted. But how did we get to this point, folks? Almost every case I consult on involves people, normally law-abiding people, well-intentioned, never been in trouble with the law a day in their lives, who find themselves in this kind of circumstance where they're compelled to use or threaten to use deadly force in self-defense when they didn't need to find themselves in that position, when there were a lot of exits off that freeway to possible criminal prosecution, that freeway to having to shoot somebody dead, a lot of exits they could have taken that they didn't take. And now they've had to kill somebody and perhaps face the risk of being prosecuted for murder as a result. There's no way that this this wife, this mother, should have ever put herself in a position where she was at risk of losing her gun to a criminal suspect. I mean, that just should never happen. And the fact that that did happen tells me, well, that was not an appropriate role for her. She was not actually prepared for that circumstance. And yet she put herself in that circumstance. And because she put herself in that circumstance, her husband had to kill somebody. Now, it looks like the father's not going to be prosecuted here, but he could be. A prosecutor could decide, hey, all right, you've got a narrative of self-defense. Fair enough. Tell it to a jury. Spend $300,000, sell your house, lose your business, get fired from your job because you're in the papers. And what if the person you had to end up shooting was of another race, like in the Ahmaud Arbery case? And now it's become a racially and politically energized case in the news. You're being characterized as some kind of white supremacist now. How's life going to look for you then? Now, that doesn't mean there's any defending a grown man looking in a 10-year-old girl's window, but it means use some prudence in deciding how you're going to deal with that situation and be smarter than these people here. By the way, this father ended up shooting this guy 4 times. Well, he shot at him 4 times. The suspect was struck by 3 rounds. So what happened to the 4th round? Did it miss? Well, it never misses, right? Fired rounds don't miss, folks. They hit something. They hit something. Someone downrange, maybe? Maybe his own wife? No reason any of this had to happen. All right, folks, we have just a few minutes left. Let me look through the questions. First on the Law Self-Defense membership site. Let's see. Scott M. asks, what is subordination of perjury? Subordination of perjury is when you ask someone to lie under oath. Now, it's very common for lawyers when they have witnesses who will testify on their behalf at trial. We prepare our witnesses. There's nothing wrong with preparing a witness. Preparing a witness is basically telling them to, hey, only tell the truth, but I want you to focus on these particular things, because otherwise, when a witness usually doesn't know what's legally important and not legally important. We all have met people at parties who talk. You only have so much time for a witness to talk in a trial. So you don't want them to get off track from a legal perspective. You want them to be testifying truthfully, but to the specific facts that are legally relevant to the case, not talking about things that are not relevant, because it just clouds the water. So when you're interviewing, you're preparing a witness for trial, you'll ask them, all right, well, tell us what you saw, tell us what happened, tell us what you know. And they'll start talking and you'll start guiding them. Look, I really want you to focus on A. Let's not talk much about B, unless, of course, you're compelled to, but that's not legally important in this case. Don't lie. Don't say B didn't happen if it happened. I'm not asking you to lie, which would be subordination of perjury. I'm just asking you to focus on these particular points because these are the ones that are legally relevant. Nothing wrong with preparing a witness. But if you tell the witness to lie, then you suborn perjury, and that's a crime, and that should be prosecuted, whether it's a defense counsel or whether it's a prosecutor's office. Frankly, it's not common for that to happen because no prosecutor or defense counsel wants to run the risk of being charged with perjury. Now, are there, can you kind of tell a client to lie without saying lie? Then we get into the realm of what's ethically permitted. But certainly if you tell a witness to lie, tell them you weren't there if you were there, tell them you were there if you weren't there, that kind of thing, a clear factual untruth, that's a crime. That's subordination of perjury. Let's see what else. No, Jerry Height says, so you're telling them what to say, bottom line. No, you're not telling them. Well, you can tell them what to say if it's true. So I don't understand your point. You can't tell them what to say if it's not true. That would be lying. That would be perjury under oath. But if it's true, there's nothing wrong with telling them to say that true thing. That's permitted. And by the way, that's why we have an adversarial process. So if there's 4 things they could be talking about, A, B, C, and D, and you want them to focus on A and B because that's favorable to you, C and D are equally true but less favorable to you, well, it's up to the other side on cross-examination to get to C and D. That's why we have an adversarial process, to flesh all that out. Let's see. What else? All right, folks, we're at the top of the hour, so I think I'll start to wrap up. My apologies for the first few minutes of the show that lacked the audio. Hopefully we have that fixed going forward. And in the meantime, I will remind all of you again that if you carry a gun so that you're hard to kill, that's certainly why I carry a gun, have every day of my adult life, so that I'm hard to kill, my family is hard to kill. Well, then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict. Until next time, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.